Hi, welcome to My Court Coach. I'm Jalen and I'm going to be your instructor as we talk about Form DV-130, Restraining Order After Hearing, Order of Protection. Now this form is only completed after a restraining order hearing or a modification of a restraining order. So for the original order, that would be after your restraining order hearing. So we already had the temporary restraining order has been issued. 3 weeks has gone by. You went to the hearing date that's on your notice of court hearing, and you won your restraining order. So you would have to actually prepare this in advance of your restraining order hearing. Typically, you would prepare this with your temporary restraining order request and the request for a domestic violence restraining order in general. You would submit this along with that packet. It would essentially be a proposed restraining order after hearing. So that all the judge has to do is fill in some blanks and sign off on it. They're not sitting there writing the name of the protected party and if there's an attorney and what that person looks like. All of that, you complete it because that information anyways mirrors your request for the domestic violence restraining order, and it could also mirror your temporary restraining order that you already have on file. So for an amended order, however, that is when somebody files to change some orders that are within the order of protection. So a very common amendment is the children. If the parties have the children as protected parties and it's been 6 months of supervised visitations and now the court wants to, or now the party wants to ask the court to remove the children from that restraining order and to allow for unsupervised visitations. That's a possibility. And so if the court grants that request, then you would go ahead and also complete this amended order. It would not be expected of you to appear at your request to modify the restraining order to have this completed. However, for judicial efficiency and so that you don't have to come back like later in the day or within the next couple of days to obtain this DV-130 from the court, you should have it prepared when you go to the hearing for the modification of the restraining order. So it's not required, but it's best practice to go ahead and have that completed as soon as you go to your modification hearing, because all you have to do is just hand over the court the proposed restraining order after hearing. And it could be blank up until, well, all of this has to be completed, but the sections that could be blank is 3 on down. And the amendment of a restraining order, by the way, is not going to extend the expiration date for the restraining order. So don't be in fear of, okay, if I try to modify my restraining order, then the court might extend the restraining order a little bit longer because the penalty for requesting to modify, and you don't have to worry about that. The date will remain as is, and the court will complete this form appropriately. So let's go through it. Name of protected person, you'd write your name. And then if you have a lawyer, you'd write their name, and then the address of the lawyer. If there is no lawyer, a mailing address or an address that you are okay with the court and the other party having. And then you can leave the telephone, email, and fax number blank if you so wish. The name of the restrained person, so the other party that you won the restraining order against. And then the description of that person, and it has to mirror your temporary restraining order and your request for a domestic violence restraining order has to mirror that information. You can't put in hair color is now blonde and on the request for the restraining order was brown. that inconsistency is not appropriate, and so it must mirror the information that is on your request for the domestic violence restraining order, including the relationship, unless the court found that there was some other sort of relationship that would warrant still a domestic violence restraining order, then that's okay too. So for number 3, we have the additional protected persons. We would list those individuals on here. We just assume that the court would grant that request. If the court doesn't grant that request, the court will usually slash the name and that whole entire section and initial next to it. And then if there's additional persons that you are requesting to protect, then you should use your MC025 and just type in DV-130 and then type in other persons to be protected. The expiration date is going to be the date that the court wants the restraining order to be expired. That's really going to be dependent on the circumstance, because some circumstances are just text messages that are constantly being sent by the other party and they're just not getting it, regardless of how many times you're telling the other party, no, I don't want you to contact me. And so the court thinks, okay, 6 months is enough for a restraining order, and I'm just going to go ahead and list 6 months from that time. Now it says here, if no date is written, the restraining order ends at 3 years after the date of the hearing in item 5. If no time is written, the restraining order ends at midnight on the expiration date. Custody, child support, visitation, spouse support will remain in effect after the restraining order ends. And custody, visitation, child support order usually ends when the child is 18. The court orders are on page 2, 3, 4, and 5 and attached pages. This order complies with VAWA and shall be enforced through the U.S. See page 5. So the hearing was on whatever date the court had the hearing with whatever judicial officer that heard your matter, and then we have to note who is present at the hearing. You probably won't be able to complete this part at all because you don't know who's going to be present at the hearing besides yourself. You must go to your own restraining order hearing. So the person in 1, you check off that because that's you, and then if the court requires you to come back at a later time to review, let's say the child custody and visitation orders, for example, then the court will complete this part for you. The court, and then this says to the other party that the court has granted the orders checked below. Item 9 is also an order, so if you do not obey these orders, you can be arrested or charged with a crime. You may be sent to jail for up to 1 year, pay a fine of up to $1,000 or both. So some very serious consequences if you violate the restraining order. Now, personal conduct orders. So this mirrors your temporary restraining order. The court is likely to grant this portion of your restraining order request. So you can't harass, strike, threaten, assault, hit, follow, stalk, molest, destroy personal property, disturb the peace, keep somebody under surveillance, impersonate them, or block their movements. You can't contact them directly or indirectly by any means, including but not limited to the telephone, email, or other electronic means. Can't take any action directly or through others to obtain the address or location of any protected persons. And it says that this item is not checked. The court has found good cause to not make this order. Peaceful written contact through a lawyer or process server or another person for the service of legal papers related to a court case is allowed and does not violate this court order. So anything related to your legal proceeding in which you are required to provide documentation to the other party in preparation of upcoming court dates, that's not going to be a violation of the court order. So do not be nervous that you would be violating your temporary or violating the permanent restraining order if you do that. Now, if you have children, there can be an exception. And that exception can be brief and peaceful contact with the person in 1, and the peaceful contact with the children in 3, as required for court-ordered visitation of children, is allowed unless a criminal protective order says otherwise. So if you do have a criminal protective order and then you're also now having a domestic violence restraining order, the orders can't conflict. So unless the domestic violence restraining order changes the criminal protective order, which the family court cannot do, but if they were to somehow do that, then that would be incorporated into the restraining order after hearing. So if the criminal protective order protects the children and then the domestic violence restraining order does not protect the children, it means that the children are still protected. And so the court actually would factor that in when they make their orders for the restraining order after hearing. So the stay away order. So the person has to stay at least X amount of yards away from person, home, job, or workplace, vehicle, school, persons, and 3, children's school or childcare, and any other location that is not necessarily a public location. And again, this is mirrors as to what is on your request for a domestic violence restraining order. The exceptions can be brief and peaceful contact with the person in 1 and the children in 3, as required by court-ordered visitations of the children, then it's allowed unless a criminal protective order says otherwise. The move-out order, you would want to write the address in hopes that the court does in fact maintain a move-out order, so you would want to absolutely fill this part out as well. No guns or firearms, so this is standard. The person in 2 cannot own, possess, or have, buy, or try to buy, receive, or try to receive, or in any other way get guns, other firearms, or ammunition. This also means that you can't have somebody indirectly purchase firearms for the benefit of the restrained party. So you can't own or have any interest in any firearms, period. So the person in 2 has to sell or store with a licensed gun dealer or turn into a law enforcement agency any guns or firearms within his or her immediate possession or control. They must do so within 24 hours of this order. Now, you should have already showed a receipt of returning the firearms to the or relinquishing the firearms to a gun dealer or law enforcement. And if you haven't, because there was some sort of exception, and now the court is telling you their exception, no longer exists for you, and we're going to go ahead and have you relinquish now your firearms within 24 hours, then you must do so. Then within 48 hours of having this order, you actually have to file now another receipt that proves to the court that you have turned in your gun, or you sold it, or you stored it. And then you must fill out the proof of firearms attachment, and so the court can know that you did in fact follow its order. And then you can bring a court-filed copy to the hearing. So this hearing actually can be the firearms hearing. Sometimes the courts do schedule a firearms hearing after your restraining order hearing, and the only person that really needs to appear on that day is the respondent or the alleged abuser by that point. If you're having this, then you are the abuser. The court has received information that the person in 2 owns or possesses a firearm. The court has made necessary findings and applies the firearm relinquishment exemption under Family Code Section 6389B. Under California law, the person in 2 is not required to extinguish their firearm. You have to specify the serial number, make, and model of that firearm, and that firearm must be in his or her physical possession only during scheduled work hours and during travel to and from his or her workplace of employment. And even if exempt under California law, the person in 2 may be subject to federal prosecution for possessing or controlling a firearm. And so, as we stated in earlier videos, the Family Code Section 6389B or H is only for peace officers or law enforcement officers, and if they have already gone some sort of evaluation that would allow them to keep their firearms as part of personal safety and in their job, then the court can exempt them. If they fail that, then the court will likely not exempt them. So This is a very particular code section. It only applies to a small population of individuals that go through, restraining orders and have restraining orders issued against them. So recording unlawful communications, the court is going to order that. I've never seen the court not order that, unless the other party, the one that's requesting the restraining order is saying absolutely not. That's very rare. And then the care of animals, the animals would definitely be protected if they are included on your request for a restraining order. You cannot go to court and ask for the animals to be protected at your hearing when they are not been listed on your request for a restraining order. So that's very important that if you do want to protect the animals at any point, then you would need to include the restraining order hearing, request for a restraining order, and you would need to include and if you don't include it and then you want to include it at a later time, then you need to amend your request for a restraining order and ensure that the care of the animals are listed on there. Now, child custody and visitation, those are going to be listed on the form DV-140. You want to make sure that that form is completed and also attached to this. Same goes for FL342. If the court does, in fact, order child support at your restraining order hearing, then the court can attach those orders to this. Property control, so if you did identify a property in your request for a domestic violence restraining order, then please go ahead and use that use the address or whatever that property is to include it in number 14. And then the debt payment, same thing. If the court actually is going to go ahead and complete that part for you, they'll also complete the section 16 about the property. So this is typically applies to married couples. So they can't transfer, borrow against, sell, hide, or get rid of, or destroy any property, including animals, except in the usual course of business or for the necessities of life. In addition, the person must notify the other of any new or big expenses and explain them to the court. The person too cannot contact the person one if the court has made a no contact order. Peaceful written contact through a lawyer or process server or other person for service of legal papers related to a court case is allowed and does not violate this order. So only for service purposes that you can contact the other party through a third party. Spouse support is ordered on the attached form of FL343. So if the court did order some form of spouse support, you would certainly attach that as well. Rights to mobile device or wireless phone account. The court, you'd want to fill out the mobile device and the account number, and then the court might order that, or if they don't order that, then they will cross it off and initial next to it. Same goes for the debt payment. You want to include the wireless provider and the amount and due date, and then you should not check off C. The court will check that off if they did grant that to you. Number 19, insurance. Again, this is typically with married couples, so neither party is ordered to cash, borrow against, cancel, transfer, dispose of, change the beneficiaries of any insurance or coverage held for the benefit of the parties or their children, if any, for whom support may be ordered, or both. So the court will likely order that if you two are married and there's not been a divorce case that's been filed already. Number 20 is lawyers' fees and costs. So the court can also issue lawyers' fees and costs. You're going to leave that blank because it's very unlikely that the court is going to issue attorney's fees and costs at your first restraining order hearing. But if you're at another restraining order hearing, then the court can make the amendment and make that amendment on this form. Payment for costs and services. So the person in two must pay the following, and you can write what those are, but do not check off the box. The Batterer Intervention Program, also do not check off this box, but it says that the person in two must go and pay for a 52-week Batterer Intervention Program and show written proof of completion to the court. The program must be approved by the probation department. The person too must enroll by a certain date, or if no date is listed, must enroll within 30 days after the order is made. The person in 2 must complete and serve Form 805, proof of enrollment for a batterer intervention program. And these batterer intervention programs can be found on the San Diego Superior Court website. You just type in batterer intervention program and a list of programs will be identified for you. And then any other orders that you had requested in your restraining order, you can go ahead and pre-type that here as well, but just don't check the box, because if the court does grant it to you, then they will check the box for you. If they don't, then they will not check off the box, and likely they will just strike it or mark it and then initial their initials. So there is no fee to serve this restraining order after hearing. If the sheriff or marshal serves it, then he or she will do it for free. But if you hire a private investigator or a process server or somebody to serve this, then whatever fee you would have to pay in accordance to your agreement with them. So service. The people in 1 and 2 were at the hearing or agreed in writing to this order. No other proof of service is needed. So this means that if you and the other party were present at the hearing, then there's nothing else for you to do. I mean, a copy of the restraining order after hearing must go to the other party at some point, but you don't need to provide a proof of service because the court has their proof by seeing that the other party is actually there. Now, the person in 1 was at the hearing, so the protected party was at the hearing on the request of the original orders, and then the other person was not present. So proof of service and the DV-110 was presented to the court. So the DV-109, the proof of service form, and then the DV-110 was also presented to the court, and the judge's orders in those forms are the same as in DV-110, which is the temporary restraining order, except for the end date. So the person in 2 must be served, and the order can be served by mail. So this just means that the court does have proof of service, that you did in fact serve the original restraining order on the other party, and that you are getting the same exact orders that are in your temporary restraining orders, and they're now going to be made into a permanent order, as you will find in this restraining order after hearing, and this order can be served by mail, so no need to personally serve it. Or the court can say that, yes, it was presented at the court, your proof of service was presented, your restraining order, or your temporary restraining order was issued, and that was also presented to the court, and the judges in this form are different from the orders in the DV-110, or the DV-110 was not issued, but the person in 2 must be personally served given a copy of this order. So if they were not present and the court changed the orders that were not on your temporary restraining order, then you would in fact have to personally serve a copy of this order, and the sheriffs can go ahead and provide that service. Now, the proof of service form FL300 to modify the orders in form DV-130 was presented to the court, and this is if you filed a motion for the FL300 through the FL300, so that's your request for order to modify the orders that were in the original DV-130, so your restraining order after hearing, and a proof of service showing that you've provided both of those documents to the other party, then the court has to check off that box. And then the people in 1 and 2 were at the hearing, so both parties were at the hearing and no further proof of service is needed. Or the people in 1 and 2 were not at the hearing and must be served a copy of the amended order. Now, criminal protective order. This is, if there is one, then the court will go ahead and try to attach that order to this restraining order after hearing. So, and if there's not a criminal protective order, then you don't have to worry about this section at all, and the court will check off that box. And criminal protective orders, the court actually has access to see whether there is in fact a criminal protective order in effect. So that's how they would also have that information. Even if you don't necessarily know, they have their own way on the bench finding out whether there's a criminal protective order in place. And then if there's additional orders that needs to be attached to this form, like a custody and visitation order, for example, then you would go ahead and identify those documents. So it says all the pages attached are part of this order. The number of pages attached to the 7-page form is, and if there's 10 pages, you write the number 10, and then you would check off all the appropriate boxes in which the attachment to this form is applicable. And then the judge would need to sign this and date it. And, VAWA does apply, so meaning that this will, in fact, be applicable and valid and enforced within all, 50 states, and shall be enforced as if it was an order of protection in that state. Now, it also provides a notice to the restrained person. So if you do not obey this order, you can be arrested and charged with a crime. If you do not obey, you can go to jail or prison or pay a fine. It's a felony to take the children in violation of this order. If you travel to another state or tribal lands, or make the protected persons do so with the intention of obeying this order, you can be charged with a federal crime. You cannot have guns, firearms, or ammunition. You cannot own, possess, buy, try to sell, receive, or try to receive, or otherwise get guns or firearms and or ammunition while the order is in effect. If you do, you can go to jail and pay a $1,000 fine. Unless the court grants an exemption, you must sell, store with a licensed gun dealer, or turn into law enforcement agency any guns or other firearms that you have or control. The judge will ask you for proof that you did so. If you did not obey this court order, you can be charged with a crime. So federal law says you cannot have guns or ammunition while the order is in effect. Even if you are exempt under California law, you may be subject to federal prosecution for possessing or controlling a firearm. And then it also instructs the law enforcement the start and end date of the orders. The orders start on the earlier of the following dates: the hearing date in 5 on page 2, or the date next to the judge's signature on this page. The orders end at the expiration date in item 4 on page 1, and if no date listed, then it's 3 years from the hearing date. Arrest required if order is violated. So if an officer has probable cause to believe that the restrained party had notice of the order and had disobeyed the order, then the officer must arrest the restrained person. A violation of the order may be a violation of this penal code section. Law enforcement or notice of proof of service. So law enforcement must first determine if the restrained person had notice of the orders. If notice cannot be verified, the restrained person must be advised of the terms of the orders. If the restrained person then fails to obey the orders, then the officer must enforce them. So consider the restrained person served or notified if the officer sees a copy of the proof of service or confirms the proof of service is on file, or the restrained person was at the restraining order hearing and was informed of the order by an officer, or an officer can obtain this information about the contents of the order in the domestic violence restraining order system. If the protected person contacts the restrained person, so what happens? So even if the protected person invites or consents to contact with a restrained person, the order still remains in effect and must be enforced. You really got to watch out for that. Don't be lured by the protected person to have some sort of lunch or conversation on the phone about something that's unrelated to your kids. I mean, this could be a violation of the order, and you would be in violation, not the other party, even if they initiated the contact. So some very serious stuff there. The protected party cannot be arrested for inviting or consenting to contact with a restrained person. The orders can be changed only by another court order. And then custody and visitation. The forms is the DV-130, items 3 and 4. They are also sometimes written on additional pages or referenced in the DV-140 or other orders that are not part of the restraining order. So enforcing the restraining order in California, a law enforcement officer in California who receives, sees, or verifies the orders on a paper copy in the California Law Enforcement Telecommunications System or in an NCIC protection order file must enforce these orders. So conflicting orders, priorities for enforcement. So if there's more than one restraining order that has been issued protecting the protected person from the restrained person, then the orders must be enforced in the following priority. So an emergency protective order, it is more restrictive. If it's more restrictive than the other restraining orders, then it has precedence in enforcement over all other orders. If there's a no contact order and there's no emergency protective order, and domestic violence, that no contact order that's included in a restraining order or protective order has precedence in enforcement over the other restraining orders or protective orders. If there are no orders, including a no negative contact, and there is a criminal protective order, a domestic violence restraining order issued in a criminal case takes precedence in enforcement over the conflicting civil court order. Any non-conflicting terms of the civil restraining order remains in effect and enforceable. And lastly, any family, juvenile, or civil order. So if there's more than one family, juvenile, or other civil restraining or protective order that's in place and that's been issued, the one that has been issued last must be enforced. The clerk must sign this, seal it, and that's what helps make it enforceable by law enforcement and to ensure the delivery and proof of service of the restraining order after hearing. I hope that you have found this to be helpful, and good luck.